courts, High Court has said that it's a fundamental right. Now, on that, can you assist us first?
And speaking for myself, I don't think we need to even pitch it that way because
no, but that is what the High Court has held.
If I may say so, the thrust of the judgment is that there is a rule which is an enforceable rule, and therefore there is a binding legal obligation to equate the dearness allowance payable by the state government with that of its central. So it is not founded on a rule. And there is, of course, not an observation in relation to discrimination. And in that context, there is an allusion to fundamentals.
We only thought that...
yes, it's not a pan-India. I realized it when your lordship's order. And this is not going to be a pan-India. In fact, there are many states which adopt the same dearness allowance pattern as that of the central government, because it is based on an all-India consumer price index.
But the court has held that it's a fundamental right.
No, but it's not really.
Not ipso facto. That's why.
Just a passing observation. It's not whole.
It's not the heart of the judgment.
In fact, the first judgment, which really relies upon the enforceability of the statutory rules, not pure and fundamental rights.
My lords, if I may address on that point, because our submissions are slightly different. We have incorporated, as my lords had asked, all the written submissions, say Mr. Bhattacharya, we received those, and those will be submitted when we begin arguments. They're photocopying now because we received some half an hour. My lords, in that, it is quite clear that with regard to this SLP, the legal right is necessary and sufficient. The fundamental right only comes in if we are looking at the next FROPA rules of 2019. Otherwise, for this SLP, with regard to the 2009 rights, legal rights are necessary and sufficient.
Why we are saying so?
Yes.
We as we read the judgment and the little bit knowledge that we had and the research we could do, we could not find any proposition thus far, subject to correction.
No, but it's not the decision of court, it's a fundamental right. Just mere observation, I shall face it not. The first judgment
allow us to.
Sorry, well, I could really follow.
We are only saying that it is this what really was we were really looking for, because can it be said that it's a fundamental right? It's something which was we were pondering, we were working on, but we could not find any material on this, so we thought that maybe this.
So, let me just place it. So,
let me just answer.
Yeah, let them answer. No, let them answer.
May I just say
also learn.
Not their argument. This, to be fair, is an argument because it had fallen from my lords.
No, it has not fallen from us. It has fallen from here.
It's fallen from the High Court. It's fallen from the High Court. That's
we are not saying.
So we have addressed that as a subsidiary argument. The crux is the legal right.
So therefore, both sides would say it is not a fundamental right. That's
not for the
no, but we'll assist you on it as
for the purpose of your lordship's question. The position under the constitution would be that a government servant is necessarily controlled by rules which are framed under the proviso to Article 309. And there are rules which regulate pay. So pay is necessarily a matter which is governed by the rules. So if a rule is arbitrary, that's a different point altogether. But to make a claim for dearness allowance as if it was a fundamental right, I think may not be.
Thank you very much.
That was not our contention also before the High Court. Our contention was enforceable right.
Thank you very much. That's what we were really looking for. We were concerned about
this allowance. Can your lordship kindly see the next word?
Appropriate to the basic pay.
Appropriate. Now, what does the word appropriate mean? Appropriate to the basic pay plus dearness pay, that is Roman 1 plus Roman 2, at index average 536, 1982 is equal to 100. So, my lord, it says that dearness allowance will be calculated on the basis of this index average. It is not indexation. And indexation is always a mobile figure based on the realities. and that is at index average. And the two words, index average.
It could have said index average as on today, which is.
Well, it is as on, in fact.
It doesn't say that.
No,
we are not the legislators. We are not.
No, I understand. There's no problem.
We are just, thinking a lot. It
Yes.
doesn't say. It fixes. It doesn't say as on.
Well, there's another, there's another rule.
Well, how do we read a statute? That's what we are.
No, I understand. And that is why, Malod, when you see these words, that is dearness allowance appropriate. How do you get appropriateness? By using that indexation. That indexation, Malod, in the very nature of things, is mobile. That is the point. That index, the word index itself means mobility.
Other than this.
Other than this, there are two other places in these set of rules where you will find.
Please, can you
yes, please. If your lordships will kindly.
If you don't mind, just
please just see, Malod, for a moment. If your lordships will be good enough to see rule 7.
Fixation, we've seen this.
Yes, rule 7. Fixation of pay in the revised pay structure. The initial pay of a government so and so will be governed and on from first day shall, unless so and so otherwise, be fixed separately in respect of his substantive pay, and so on. And then your lordships will find, if you come to the proviso law, the one above note 1.
Yes.
Provided the pre-revised dearness allowance appropriate to the existing non-practicing allowance admissible at index average of 536, 1982 is equal to 100 shall be added while fixing the pay in the revised pay band and the amount of non-practicing allowance at the rate so and so. So, Malok, as on the date of revision of pay, you actually employ this formula of indexation. That is to Roman 1 plus Roman 2, you add this index formula. But that index formula means that as and when it changes from 536 and it goes elsewhere in that sliding scale which was shown, then Manoj, it adjusts itself. So Manoj, really the rule is one for adjustment in a pay band. Manoj, in a pay band, there's an adjustment. Okay. This is the point. But I must say, Manoj, it's a brilliant point taken for the first time. I have no objection. The point is a good one. It should be dealt with.
Just 1 minute to add, with your lordship's kind permission.
Yes.
Please see the same definition. Indexation comes in by the use of one expression and some words. It says dearness allowance appropriate at the basic pay plus pay at index average. Index average is a well-known expression, as Mr. Diwan's note number 3 and 4 points, it showed to your lordships that this index average is given by the Labour Bureau twice a year on 1st January and 1st June. I'll just read point number 2 and 3, which he has said. This index average is published by Labour Bureau. Point 3. The Labour Bureau revises the index average twice a year on 1st January and 1st June. The broad purpose of this index is to enable adjustments with respect to inflation. Therefore, dearness allowance, as we all know, has two components. Dearness allowance appropriate to basic pay, which is fixed when the pay revision takes place by the pay commission. And the second component of dearness allowance is dearness pay. Dearness pay is never fixed. It is always linked to inflation, which is consumer price index. So therefore, your lordship may see the plus dearness pay at index average, and we know index average comes twice a year. And why should it slide? The next 82 equal to 100 has to be given some meaning. If 1982 is equal to 100, when I'm getting pay in 2010, we will have to see this 100 also, what it is. So therefore, this 82 equal to 100 is very crucial. So the rule tells us when you are fixing dearness pay on the indexed average, you will take 1982 as 100. Then what do? You see the index average for that year and give the dearness pay. Now, therefore, 82 equal to 100 is very crucial when your lordship actually sits down to interpret the rules.
See, you want us to read into...
No.
add something to the statute. Anyhow,
No,
we'll look into it.
Index. Now, two more points. Number one, the proof of the pudding is in the eating.
Is there, Mr. Diwan is not there, Mr. MP is there. Mr. Gopal Subramanian, we tell you. We don't shy away from saying so we want to help you. You are government employees, you serve the government, you will have to tell us how can we help. We'll continue the
And what we have understood is that having held that court cannot issue a mandamus for grant of central DA. Now the court has granted it, according to them, court has granted the same by applying ACPI. That is the crux. That is what their submission is.
Correct.
Having said that, it can't do, they have done it, the High Court and the tribunal, by applying ACPI,
That's the point.
But according to us, what the High Court and the Tribunal.
and according to you and the High Court, ACPI, the application of this, what is this, ACPI,
Yes.
AICP, is inbuilt in 3C.
They built the rule.
Inbuilt in 3, that is your case.
Yes, and it is from time.
Court has not applied any alien formula, it is inbuilt in 3C3, that is what your case.
Yes.
Their case is the rule makes it static. We say
We can't be more clearer than this.
correct.
As of now, the task is not as simple.
We are
as-
testing us whether